Hello, welcome everyone. Thank you for joining this presentation that we put together on the changes to Florida alimony. I'm Jason Soman. I'm a divorce forensic accountant and business valuation analyst headquartered in Boca Raton. I'm joined here by Scott Kalish, family law attorney, managing partner of Kalish and Jaggers, a family law firm in West Palm Beach. Scott is also host of the Florida Divorce Podcast. And I also have here Don Mall, who's a certified divorce lending professional. Some of the alimony impacts also impact mortgages. And Don and I were talking, and we said we'd love to have you on this broadcast to kind of talk about how these changes in alimony impact getting a mortgage, because obviously getting a mortgage and dealing with the house is usually one of the biggest issues in a divorce case. So welcome, gentlemen. Thank you for coming together on short notice. The alimony bill just went into effect July 1st, so we're not even a week old. And, I preface this conversation to just tell everyone, we're still unpacking this. There's a lot that people are still understanding about the alimony bill. And we're going to just give you our initial thoughts, kind of cover the basics, but I'm sure that this is going to unfold over the next many months and years to come. I mean, Scott, you said that people are already calling up asking about alimony, right?
Oh yeah, no, several calls. I mean, at least 2 or 3 calls a day about, people eager to find out if they're able to, modify their permanent alimony and whether or not they can get some relief, right? So everyone's very eager. I had a guy call a couple of days ago, like 4 times in the same day, just trying to get me on the phone. Unfortunately, it was all booked up that day. He's going to have to wait until next week to talk. But yeah, no, people are definitely hot on this issue for sure.
So I know we have a wide range of audience here. We have people who are probably contemplating divorce, may not even know what alimony is. And we have, family law attorneys on that have been practicing family law for 20 years or plus. So I thought that maybe I'd just start off, Scott. Maybe you could just explain what alimony is just at a very high level.
Sure. Just on a high level, if you think about, what child support is, right? Child support's obviously, support that one spouse or one parent really pays the other, spouse or parent, right, to support a child, right? And alimony is sort of analogous to that. It's support that, one spouse pays to the other spouse to really support, that receiving spouse, right, the payee spouse. And it's really based on, and it's still based on the person asking for alimony, their need, right? Are they able to go out into the workforce or, have an income that meets their, expenses, right? And really, meets their standard of living. And then also whether or not the, the payor spouse, the spouse that's going to be paying the alimony, whether or not that they can, whether or not they have the ability to pay the other spouse's need, right? The other spouse's alimony. So what we're talking about here is money going from one spouse to the other spouse to meet their expenses, right? Their living expenses.
And alimony, it feels like this is a very charged issue, right? Like people get fired up about it. They hate paying it. And people that are receiving it depend on it. I mean, isn't it? Do you find that this is more of a contentious issue that people are
fighting over? It's definitely a polarizing issue. And depending upon who I'm representing, right, you kind of handle it a different way, right? Approach it a different way. But yeah, no one wants to pay alimony. Very, very few people voluntarily are eager to pay alimony. It's definitely, a hot issue. And it's something that, definitely prevents cases from settling. And it's an issue though that we're still going to have to grapple with. Right. But there's definitely been some changes as obviously we're going to talk about.
So I guess how did we get here? Because I feel like the issue of alimony reform has been something that people have been talking about a long time, even longer than I've been practicing in Florida. Like, how did this all happen?
Yeah, no, I mean, I don't know too much about what's been going on behind the scenes. I'm, super busy with my day-to-day practice that I'm not really able to track what's going on up there in Tallahassee. But, my understanding is, it's been a long battle up there for about 10 years. And last year they were very, very close to passing alimony reform in Florida. And Governor DeSantis decided to veto that law last year because it had a retroactive effect, right? And I believe the word from the governor's office last year was it would really wreak havoc on people's lives, to start undoing agreements, undoing, judgments that were, put in the past, or made, law essentially in people's lives in the past, to start reopening cases. It would just, I kind of saw a taste of it this week. Once the new law passed, people are calling because they're not really, sure, they're lay people, right? They don't know what can be done to their case, their individual situation, now that this new law is passed. And yeah, I think that was a smart move by the governor. I think, reopening, a ton of cases would wreak havoc in people's lives, and also on the judicial system, right? It would just it'd be overload for sure. So yeah, that's essentially what's been going on, and I think this law really strikes, happy medium in terms of, I think both sides. I think it's a balance for people wanting alimony and people, opposing alimony.
So, this law that went into effect, like, it covers more than just alimony, right? There's some other topics that are kind of mixed in there as well. We're going to only kind of cover the alimony on this broadcast, but we will talk about other things on future broadcasts. I know that there's changes to time sharing and modification and so on and so forth. So I thought next, maybe Scott, you could just kind of give us a little bit of the highlights that impact alimony in terms of what this bill changes and how it impacts it.
Sure, we can go into them more specifically, but really the highlights, the most notable highlight is the elimination of permanent alimony in Florida. Florida was only, one of a handful of states in the United States that still had a form of permanent alimony on the books. So now, we're joining the majority of the states in the country that has now eliminated that, which is huge, right? I think permanent alimony, especially really in long-term marriages, was something that was, was there for a ton of people. So that's huge. Definitely changes the game big time. There was impacts on, how long durational alimony, right? Durational alimony is a type of alimony that Florida still has, and there's some restrictions that the legislature has placed on that, as well as restrictions in, or the categorization of the lengths of marriage, right? Before we had, short-term marriage, moderate-term marriage, long-term marriage, right? And each one had, we'll talk about it, I think a little bit more, but each one had a, set time that it was defined as, and the legislature changed that up a bit and made some changes there. They've also added some more guidance regarding when one spouse, right, the payor spouse, can retire. And they've also added a mechanism, more language regarding supportive relationships. So obviously part of the old law was, if the payee spouse, right, the spouse receiving the alimony was engaged in a supportive relationship with another person, that could be grounds to terminate alimony. So we've got some more language there.
So everyone's talking about permanent alimony. Maybe you could just take a step back and explain, like, what permanent alimony is. Like, was permanent alimony ever permanent, like actually permanent, or how does that work?
Well, yeah, potentially, right? So permanent alimony, what the law was that, hey, if you had a long-term marriage, a marriage a week ago that lasted for longer than 17 years, the presumption under Florida law was that any alimony awarded be permanent. So, if you had someone that got married when they were 20 and all of a sudden they're 37 and they get a divorce, right? Potentially they could be receiving permanent alimony for the rest of their life, really. So now obviously we don't have that anymore. As of last Friday, they've totally eliminated permanent alimony. So that's not really going to be a thing. But yeah, it has a huge impact in certain cases for sure.
Okay, so maybe we could talk a little bit about the duration. I think you mentioned it before in terms of the length of the marriage. The length of the marriage is kind of what drives how long you're going to have to pay alimony for, right?
For sure, yeah. It definitely places certain restrictions on awards for alimony, right? So before a week ago, short-term marriages were defined as a marriage that lasts from, let's say, a day to 7 years. That's now been extended to a day to 10 years. So they've added 3 years on what's considered a short-term marriage. For moderate term marriages, it was between 7 and 17 years. Now it's between 10 and 20. And then a long-term marriage is for a marriage that lasts, from 20 years, onwards. So that's how they changed that. And before, the cap was for durational alimony. You could not exceed the length of the marriage. Now they've totally eliminated durational alimony, which is really a catch-all type of alimony, right? It's not bridge the gap. It's not rehabilitative alimony. It wasn't permanent. Durational alimony was sort of like a catch-all type of alimony. And that, like I said before, it's now eliminated in any marriage that lasts for less than 3 years, which I think, now it definitely, restricts people in that regard. And then in a marriage that lasts anything from 3 years to 10 years, it could only be awarded for 50% of the marriage. For moderate term marriages, it may not exceed 50% of the marriage, I believe. And then
60%.
60%, apologize.
Right.
And then for long-term marriages, it's 75% of the length of the marriage. Thanks, Don.
Sure.
Appreciate it.
I stayed at a Holiday Inn Express last night.
So, I thought this would be a good time for Don to kind of introduce himself, tell the listeners a little bit about what he does and kind of why this impacts getting a mortgage. I mean, every time I listen to Don talk, I always learn a ton. I mean, sometimes when it comes to divorces and mortgages, kind of you don't know what you don't know. So I'd love to hear, Don, a little bit about what you do and kind of how these new modified durations may impact the mortgage process.
Sure. I probably have the one, I'm looking at our screen here, I probably have the one designation that nobody knows what in the world it is. So
I don't know half of Jason's. I know the first one. Everything after that, no idea.
So mine is a certified divorce lending professional. So believe it or not, there is a designation. There's roughly, now about 225,000 licensed loan originators in the country. A little over 800 have actually earned the CDLP designation, meaning that we focus our practice on divorce and how to navigate the different parts of the divorce process, because the mortgage process is completely, during the divorce process, is completely different when actually the couple purchased the marital home. So when I saw this new legislation, what jumped out at me was specifically what we were just talking about with the durational marriage, and that is for any marriage, what considered short term now, any greater or equal to 3 years, but less or equal to 10 years. That's going to be an issue, and let me explain why. So when it comes to using alimony for qualification purposes, for whether one spouse is looking to retain and refinance and do an equity buyout of the marital home, or the spouse is looking to purchase a new home and using alimony for qualification purposes for the mortgage, we use it as lenders, but there are guidelines that we have to follow. So before we can use alimony, in this case, for qualification purposes, our judge is the underwriter. The underwriter is going to want to see that the payor makes those payments for, if we're going to do a conventional loan, 6 months as ordered before we can even start a mortgage application. So when I say as ordered, that means, let's just say the marital settlement agreement states, well, there's $1,000 due on the 5th of the month. And the payor says, well, I'll pay $500 this month, and I'll pay $500 on the 5th, and I'll pay $500 on the 15th. Or I can't pay this month, but I'll double up next month. That's going to present a problem because we have to meet what's called the stability and consistency with that. But bottom line is, the underwriter is going to want to see that payor make 6 months of payments before we can start the mortgage application. And then the underwriter is going to say, okay, now we can start it. Now I want to see that these alimony payments are going to continue for a minimum of an additional 36 months from the date of the application. So in essence, if you add that up, 6 months on the front end before we can start the mortgage application, 36 months on the back end that we need to show those payments continuing in the settlement agreement, that's 42 months. So when I saw that the durational alimony is going to be limited at 50%, anyone that's not married, in this case, 8 years, so 7 years minus, they're going to have an issue if it's just written up as this new law states. So I think that's where, obviously, before signing a settlement agreement, that if you are negotiating alimony for a spouse, that you do get it reviewed by someone with those acronyms CDLP next to it, just to make sure that the client can effectuate that part of the marital settlement agreement. And Scotty, this is back in your lane, but wouldn't it be very feasible to say, okay, well, if part of this settlement agreement is to purchase a new home or refinance, do an equity buyout, to maybe lessen the alimony award so that the duration would fit into qualification guidelines?
Yeah, absolutely. I mean, if the other side is willing to do that 100%, and it's almost a matter of cooperation. And if there's some leverage in another area, maybe you use that in terms of negotiation to try and get the duration longer, the amount shorter. We're talking about the same amount overall, but if that's what it's going to take to keep the house or to refinance the house, then that's what I think people will do if they find themselves in that situation.
And a key word that, well, some language that I saw that jumped out, this is almost a starting point, right? These new guidelines. And like Jason, you said, everyone's still unpacking this thing. But what appears to me is that this is a starting point. Okay, been married X amount, in this case, maybe 8 years, you get 50%. That's the starting point in the negotiations, right? And then
that's now the ceiling, right? I mean, that's what's going to be interesting to see how negotiations are going to play out as cases kind of work their way through the system and we start applying this new law. Before it was with durational alimony in, let's say, moderate term marriages, it was all right, we'll start off with the length of the marriage, right? Alimony for 10 years if the case, if they were married for 10 years, and then we kind of work from there. Long-term marriages, we start, the person asking for alimony usually starts permanent. So then we kind of work back from there. So this is definitely going to impact how negotiations, ultimately shake out. I can tell you, from being a part of, a ton of mediations, usually, the sweet spot is half of the marriage, right? And it's interesting in that the legislature chose to cap it at half of the marriage. So this is definitely going to, it's going to be interesting to see what judges end up doing, because that's probably going to set the tone for how mediations and negotiations end up happening, right? What people are willing to settle for. If judges are going to be giving, the maximum amount on these cases, then that's maybe we still settle cases for that. But if they're going to be cutting that in half or deviating from that, then it's going to be a matter of it's going to be a case by case basis in terms of where these cases end up settling for.
So Scotty, what would be the process? Say someone has and signs a marital settlement agreement that, let's say, kind of bring it selfishly here to my world, but they sign it and it's got 24 months or 36 months of alimony payments, and then they realize, hey, I didn't get consultation or didn't know prior to signing it. Now it's signed. What's the process for them to go? Would that be an amendment? Would it be an addendum? What would have to happen there? I
mean, you can do an addendum, right, to the agreement, and renegotiate it, so that they can now qualify for their mortgage, right? If they need to extend those payments to have the requisite amount of months, right, of support shown for purposes of refinancing. Sure, I mean that can definitely be done, but it's a pain, right? Money that the person that's trying to amend has to shell out, and probably money the other party is going to have to shell out to make sure that an attorney's eyes reviews the addendum to make sure everything's right. Maybe get it filed by the get it filed in court and potentially doing a supplemental final judgment just to make it the law of the case, right? So it's unnecessary hoops that have to be jumped through, and I think having someone like yourself part of the negotiations to at least just educate, right, and inform the lawyers, inform the parties of what has to happen in order to accomplish their goals is really clutch. It's what has to happen.
So
Jason, Well, I was going to
Yes.
ask you, Jason. So there's in terms of like the guidance on the new guidance on the amount. I'm sure you can give us some insight on how that has changed, right? I know that the legislature included some language regarding calculating the amount. Before it was really need based. Now it's something else, right? Or sort of like some additional language that they added.
Sure. So I have the new bill up on my other screen. It says the amount of durational alimony is the amount to be determined to be the obligee's reasonable need or amount
Obligee.
not to obligee's
It's all good.
reasonable need or an amount not to exceed 35% of the difference between the parties' net incomes, whichever amount is less. So based on how we typically would do it is we would calculate a range. We would look at, I don't know, at the combined income, the combined net income of the parties, look at it can't be more than 50%, right? Because that would conflict with the law, which states that the payer of the alimony can't have less net income after paying alimony than the recipient. And then we would look anywhere maybe from a 30 to 40% range and calculate what that would be based on the combined net income. So now the law says that it shall not exceed 35% of the difference. So now we just have to look at what's each party's net income and then what's the difference between that. And now it seems like there's a hard cap on it. And maybe I'll defer to you, Scott, in terms of what the law was before. But from my understanding, it was kind of a little bit subjective, right?
No, yeah, you nailed it. I mean, you can't leave, the payor spouse with less than the recipient spouse. That was really the overarching, principal theme of the amount of alimony. But yeah, no, you definitely nailed it. I mean, could you give us an example of what an alimony payment might look like at 35% of a difference?
Sure. So what I did is I just went through an example and I started doing math and just trying to get a feel for like what the amounts. Can you guys all see my
Can
screen?
you zoom in maybe a little bit?
Sure.
It's a little small on my screen.
So I used an example of a couple, one person, the high earner had $250,000 a year in income. The lower earner had $50,000 a year in income. So that would leave the higher earner with $15,000 a month, the lower earner about $3,500 a month. So the alimony payments at 30% of combined net income would range from about $2,100 on the low end, and at 40%, it would be about $3,900. So after July 1st, the calculation works a little bit differently. It calculates, well, what's the difference in net income? So in this instance, the difference in net income is $11,600. So the 35% that the law mentions, that will end up giving you a higher alimony payment in this situation of about $4,100. But I imagine, Scott, as this thing unfolds, there may be the law says that it shall not exceed 35%. But I imagine that people are going to start making arguments as to why it should be less than 35%.
Or their need, but the law does say, it's either, the need or 35%, whichever is less. So I think, the focus is probably going to be on, the need and minimizing need, right? Doing needs analysis and figuring out, what the payee spouse needs to live, right? And try and minimize the alimony payment as much as possible, right? If you're the payor spouse or representing the payor spouse, right? If you're an attorney.
Yeah, because if let's say your need is $10,000 a month, you're not going to get alimony that's going to get your net income to $12,000 a month, right? It's not like you ever get a bonus. Like there's no alimony bonus or saving component to alimony. I imagine that's still the same in this new law.
Yeah, no, that's my understanding, right? It doesn't really say that in the act, but that's our case law. That it's and it makes sense, right? It's alimony is to meet a spouse's need, right? Unfortunately, the law has taken, or depending on who you ask, right? Unfortunately, the law has taken the stance that, hey, saving is not necessarily a need, doesn't fit into what's quote unquote a need. A lot of people would disagree with that. Everyone likes to have a safety net, but technically not a need. So it's not, part of alimony. You don't get that.
Yeah, and I know there's a lot of a language in the new law that talks about like burdens of proof and things like that. Is that something that you feel has changed, or is that kind of still the same?
No, based on my review, and again, this new bill is like 23 pages, but based on what I reviewed, I don't really see a huge change in the burdens. I think the spouse asking for alimony still has the burden to prove need and ability to pay. There is that additional language about possibly extending durational alimony, not being clear and convincing evidence, right? That I think is new. I don't think there was a clear and convincing evidence standard, which is higher burden of proof than preponderance of the evidence, which is 51%, just the greater weight of the evidence type of thing. Clear and convincing is, definitely elevated from there. It's going to require additional evidence, more proof.
Yeah, I also feel like there was a lot of red line changes, maybe they just kind of tightened up some language here and there, and they I saw something they added mental health to
I saw that. That was interesting. Yeah. And they kind of had emotional, I think, health, right? But then they added physical and emotional. I have to pull that language, flip to that page, but yeah, they added mental health. I thought that was interesting. I think it makes sense though to add that in there.
So maybe we could just touch briefly about modification, and you mentioned a little bit earlier about supportive relationships. Do you think that there's any difference now with the new law in terms of modifying alimony?
Yeah. So this is an area that really, I want more time to review and compare to the case law, because the case law has definitely, done a ton at fleshing out what the statute said before. But I can see brand new, what they added that, an obligor can file for a modification based on a supportive relationship that the other spouse was in, right? The receiving spouse was in, that existed 365 days before the filing. So that's new. And that's interesting. I feel I think that's fair, right? And I think it cuts down on the games that are sometimes played. Obviously, if you're remarried under Florida law, that's grounds to terminate alimony. If you're in a supportive relationship, it can be as well. So I think giving the people the power to look back a year, I think that's important.
Yeah, when you say supportive relationship, what do you mean by that? Is that someone is paying for your expenses, or?
Yeah, it's a term of art, right? And it's been defined by the case law. And don't quote me, right? I don't have case law in front of me, but it's really based on in my opinion and my knowledge of the case law, right now, without looking at it, that it's based on being in a relationship that is really what a traditional husband and wife relationship is. You're both supporting each other, financially and otherwise. It's not just, a roommate, so to speak. It's not cohabitation. It's more than that. It's, you're, I think facts such as you're sharing bank accounts, you're paying for groceries, but the other person's paying for rent, that type of thing, right? Sharing of household expenses, as you would in a husband-wife relationship, right? You're not going to have a joint checking account usually with a roommate. You know what I'm saying? They're going to pay you rent, and that's going to be it. A supportive relationship is more than that.
So you can't really game the system just to keep your alimony and say, well, I'm not going to get married until my alimony.
You can try. You can try. I mean, people do that all the time. And that's where the difficult part is, right? Because, if you're receiving alimony, you should be able to date people and kind of, try and restart your life after divorce. But the law obviously doesn't want you to, try and play both, right? Get the alimony, but then kind of be with somebody else and being supported by somebody else. It's almost like, it's not, it gets into the territory where it's not fair, to the payor spouse. Like, hey, he shouldn't, he or she shouldn't have to fund the other person's, new life when they've already, moved on financially, and now there's no quote unquote need anymore. Right. So that's where you get into trouble.
Yeah, Scott, and I know we were talking a little bit about this before, but is it safe to say, like, some of this new alimony bill, it kind of codifies things into the statute that may have just existed kind of, I don't know if informally is the right word, but anecdotally in these cases that went to trial that serve as the basis of your case law, and now maybe they put certain things down into the statute. Is that fair to say? Or
Yeah. No, I think it's fair to say that's what they did with the retirement. The case law was that, hey, people had the right to retire, once you're 65, and under, in terms of Social Security, that's like the presumptive age that you can, retire. And that's a reasonable age to retire. And the case law was, if you were retiring, at 65, and because of that retirement, your income takes a hit. Yeah, that would be a reason for basis for a modification. And that's really what they did here with that. And there's, a tremendous amount of guidance in the new law. It's going to make it easier for people to retire for sure, especially for purposes of, the actual case, right? Moving through the system. So, as soon as that modification gets filed, the other side, all they have to do is look at the statutes. They don't have to go into the case law and figure out what the actual law is. It's right there. It's black and white. So I feel like that it should cut down on overall litigation costs.
Scott, this is a personal that comes to mind, but I've got a buddy that he actually got married. He was in law school at Gainesville, got married, and then he must have been mid to late 30s when he got divorced. He's in his 70s now.
Wow.
And I know he's been paying $3,000 a month. So is he able to modify this, or does it matter? I know some settlement agreements will say modifiable and non-modifiable.
Yeah.
Is that going to be the issue there?
It depends, right? Yeah, for sure. I mean, obviously, the first thing that I would want to look at as an attorney is I want to look at the agreement. What does it say? Sometimes, like if you're trying to make these things ironclad, you go above and beyond to make it to where there's no possible way it can be modifiable, right? Like, including language such as like this shall be non-modifiable no matter what happens, if the law changes, if whatever, right? So
really,
that's where I'd want to look first. But in terms of retirement, if he is retired, then yeah, I mean he can, and it's modifiable, right? If the agreement is modifiable, then potentially he can use this. But there would have been an avenue beforehand if he had retired. But I imagine if he's 77 and he still has the ability to pay, the $3,000 a month, then I mean, potentially it could continue, right? If it's permanent.
Even with this new law, and then even if it's modifiable.
Yeah.
Okay.
Yeah.
Right. Well, I anticipate a call from him. That's why.
Yeah, I'm sure. Do we have any questions from the audience? Anybody have any questions?
We had a commenter, Robin Schur. She said depends on the agreement, which I think that she I think she still has her wooden spoon that she won at the Florida Bar Convention.
Hey, Rockin' Robin.
So
she loved that spoon. I don't think I've ever seen her smile so happy.
So maybe I just ask you guys, like, I guess, what are your main takeaways from this law? Who is it good for? Who is it bad for? Does it change everything, or what is your take on what happens from here?
I mean, I think it's good for obligor spouses, right? In long-term marriages, I think it's great for them because capping it at 75% of the marriage, and that's where the cap is. So in terms of mediation and negotiation, I mean, it's going to be cut down from there. I could already feel it. So, I mean, it's bad for, like I said before, it's bad for people that depend on alimony in long-term marriages that are probably in their, early 50s, mid 50s, that don't have a ton of skills or aren't going to be able to, go out into the marketplace and earn enough money to replace what the income that really, they required to maintain the same standard of living long term. I mean, it's going to be there's going to be major changes, and I think it's also maybe a reflection on the society that we live in. I think I saw that maybe I don't know if that was, one of our legislatures that said that, that was quoted in one of the articles I read, but it's a product of the society that we live in, right? I mean, the ability, right, to get information and gain skills is, really unprecedented, right? So people are definitely going to have to, make changes, long-term changes, right?
Yeah, and I'm going to show one of our comments from Paola Harris. She says it's going to be very good for family lawyers, meaning I imagine you guys are going to be busy looking at these changes and analyzing these things for many months and for many years to come.
Yeah, no, but I mean, I'd be interested to. So, I mean, yeah, I think it's good for family lawyers in terms of streamlining cases. I think from a financial perspective, right? People that bill hourly, it's definitely going to be, less fees attorneys could charge for litigating, because now it's way more certain, right? I mean, we're not talking about, when you have a case that there's a long-term marriage and then alimony is on the table. Usually the issue is permanent alimony, right? And and that's kind of what drives a lot of these cases to trial sometimes. So once you eliminate that and you put a cap, I mean, it limits, I think, people's exposure, right? So I think these cases are going to settle. So yeah, I mean, if you're a practitioner and you like settling cases, like, getting them done smoothly, efficiently, then yeah, it's great for sure.
So we got a question in from Josh Schultz. He says, what can a payee do to offset some of the impact of these changes?
I mean, I think gain skills, right? I mean, what do you think? I mean, listen, when people come to me, sometimes potential clients or clients, they say, hey, I'm out working, do you think I should go get a job? And what I 90-something% of the time I say yes. I say, you'd rather have your own destiny, your own fate in your own hands, right? Rather than depending upon somebody else. Because yeah, the judge can order alimony be paid, but as well as I do, if the obligor is a business owner, trying to enforce alimony against them can be difficult, right? So I'm a huge proponent of, go out, if you got to go back to school, if you have to learn, skills, additional skills to get a higher paying job or to re-enter the workforce, I'm all for that. What do you think, Don?
Well, I know looking back at the language of this thing, and it's how the court can consider evidence. It was under the section. It's actually, want me to get nerdy on it, 61.083.
Yeah.
There's actually 7 alimony factors, and then there's an 8th catch-all. But it goes, again, I can't stress enough, even before this, 2 weeks ago, I was on a case, and the proposed agreement had the spouse that was supposed to refinance the marital home was awarded 24 months of alimony. And I said, well, you got a problem if she's going to be using this for supporting, for qualification purposes, right? So it's kind of like an aha for everyone involved. And there was there was 4 professionals in this case. So yeah, I mean, that again, my role is very, very, very niche here, but when you're dealing with where people are going to live, it's kind of a big deal. So that's why this jumped out jumped out at me. So
yeah.
And for on my end, I feel like a lot of the questions that people have is like, well, what's the income, right? I mean, and I still feel like can be a very complicated question to answer in many instances, and I don't know that changes now that the calculation changes. I think it just, once we determine the income, there may be a different mechanism by which we make our calculations, but it's really figuring out sometimes what a business owner's true income is and the perks and the distributions and, below market items and above market items and things of that nature. I still feel like at least my job is safe, for at least until ChatGPT or anything takes over.
Yeah.
I think that some of the comments in Renee Harris she's interested to see if, how it's going to play out with our awards going to ever increase above 35%, because it seems like the law kind of leaves that some language in there that gives the ability to kind of go above the statute.
No, I don't think you can go above the stat. Can't go above 35%. It's going to be whether or not it's going to be below. Like what's going to happen, what the arguments are going to be regarding the need versus the 35%. It's going to, that's what I think is going to be, the focus and what people are going to try and latch onto. To try, people that are defending the payor spouse, they're going to try and put the spotlight on the need and say, oh no, he or she doesn't need 35%. They can get by with less than that, 15%, 20%. So they're going to do. I think they're going to focus on doing a needs analysis, right, to try and.
Doesn't it really go back to needs and ability to pay? Are those the two?
It does. No, it does, and that's why they I think they left that in there to say, hey, the max is 35%, and then the minimum is need really, and it's whichever is less. So if you can if the need if your need is what it is and it's less than 35%, it's what your need is. So I think it makes sense based on the evolution of our law, right? And the fact that there is no savings component, I think it makes sense.
Well, Jason, I guess we were in Boca for the Florida Bar Conference last week before, and I was picking your brain. How do you determine income? And it's completely different. It was eye-opening me how you determine income in your world.
Yeah,
and how
I
we
think
determine
I think that we're going to do another podcast episode with Scott to talk about how we determine income versus how Don's mortgage underwriters will determine income. Because I think when the last time we were on a podcast with Scott, we were kind of talking about it, and then when we reconnected at the Florida bar, we were like, oh well, this is a topic that I think we could really explore further, because there's quite a bit of nuance in terms of what's the income that's going to be used in a child support calculation or an alimony calculation versus what's the income that's going to be used on your mortgage application. Do you think that there's and maybe switch gears, I'm just looking at some of these comments that are coming in. I definitely think that there's a swath of people who maybe haven't worked in a long time, especially in Florida. We have a lot of retirees who live here that may be depending on alimony. I definitely think that there's, we'd be remiss if we didn't say that there may be certain people that kind of feel like the rug has been pulled out from underneath them. I mean, I don't know if that's something that you foresee. Well,
going back to that section 61.08, if you go down to its section E, it says earning capacities, educational levels, vocational skills, employability of the parties, including the ability of either party to obtain the necessary skills or education to become self-supporting, or to contribute to his or her self-support prior to the termination of the support, maintenance, or alimony award. So I think a key word there, including the ability of either party to obtain the necessary skills. So that's, Scotty, what do you see happening there?
Yeah, no, I mean, it's that's why we hire vocational experts, right? To come in and do an evaluation and say, hey, this person has this skill set and they're able to make this money with this skill set because these jobs are available and they're just choosing, not to work. So, hey, Judge, I want you to impute income to them to the level of what they can make out there in the marketplace. So it's definitely going to get a change. I saw a comment before about, what was it about? Fewer people staying home, right? I mean, that's what it's going to be. I think, I mean, the focus is going to be on, what people can make, right, and what income they can receive. It's not one-sided anymore. I think that we did have somewhat of an archaic alimony law before this. I mean, not totally, right, because you could still include, right, imputed income if someone was either voluntarily unemployed or underemployed, right? But yeah, no, it's becoming more and more difficult. And hey, with the elimination of permanent alimony, I mean, tell you what, especially people that get married at a very young age in their 20s, you can be late 30s, 40s and getting permanent alimony. I don't think that was fair. I just don't think. I think if someone was in their mid to late 50s, permanent alimony, yeah, sure, I can see that, but not someone in their late 30s, early 40s. You still have a whole lifetime to live. And go back to school, get new skill sets, and I think this law is a reflection of that shift in mentality, right? So.
Absolutely. And this has been great. As I mentioned before, we're still unpacking this. I think there's going to be a lot more people talking about this. It just came out less than a week ago. I encourage anyone. I don't think we're going to be able. A lot of comments came in, and I'm happy about that. But I encourage anyone who wants to chat a little bit more to reach out to Scott, reach out to Don, reach out to myself. We'd love to continue the conversation. Scott, where could people reach you if they'd like to talk about alimony?
Yeah, no, I mean, if you have any questions, I'm always, happy to chat via email, right? My email is Scott, SCOTT, at KJLawFLA.com. Again, Scott at KJLawFLA.com. And
Don, how about yourself? Where could the listeners reach you to talk about mortgages and divorce?
Well, who wouldn't want, if they're having trouble going to sleep at night, they can call me. It's, well, I guess they can find me on here, right, on LinkedIn, or they can go to my website, which is thedivorcemortgageguy.com. So relatively easy, thedivorcemortgageguy.com. And this is completely out of the channel and I don't get People Magazine. I think it's because I've watched a few episodes of Yellowstone, and now on my news feed, I get stuff about Kevin Costner. And that's now, he's going through a divorce. And if you saw, it was the news feed came up today. She's asking for $248,000 a month for child support.
Okay.
Yeah.
Where are they getting divorced? What state is it?
They're in California.
California. All right.
Yeah. Have you ever come across that kind of a figure, $248,000 a month?
No. One of the highest, though, I got a call 6 months ago from a.
That's a lot of new sneakers.
Yeah, no, for sure. It was a paternity case, but yeah, no, the father was a professional MLB player, and she was telling me, approximately what he was making, and I had her on the phone, and I pulled up my child support guidelines, and I was kind of running scenarios, and definitely wasn't 250 or around there. I think it was like 10 to 20 to 30,000 a month. It was,
wow.
But yeah, no, but I mean, I think his income definitely in the multi-millions a year. So it's interesting.
All right. Well, if you'd like to learn more about me and my firm, please visit us at www.divorceforensicaccountant. We're going to do this again. Scott's a frequent guest of mine on a podcast I have, Find the Money podcast, and I'm a frequent guest on his podcast, the Florida Divorce Podcast. So we're always collaborating and looking for ideas, and we'd love to, invite on people in the audience to collaborate in the future. I'm really happy that we had all this engagement, and look forward to continuing the conversation and for all the professionals on the line tackling these tough questions for many years to come.
Definitely. Thanks, guys.
All right.
Pleasure.
Care.
Take care.
It was great.